the extremely engaging event. My name is John Raymer. I'm one of the co-presidents of the Federalist Society. Today's event is about what is colloquially known as the travel ban, or travel bans, as we'll hear from the speakers. The event we wanted to host is about debating the constitutionality of the travel ban, not about whether the policy is a good idea, whether it's something we should do or not, but rather this is something that whether this is something that the President of the United States can legally do. We have two excellent speakers here to debate this issue. The first one joining us all the way from Texas is Professor Josh Blackman.
And I'm a Penn State alum, sorry.
He's a professor of law at South Texas College of Law, Houston. He graduated from George Mason School of Law. He clerked for Judge Gibson in the Western District of Pennsylvania and for Judge Boggs on the Sixth Circuit. He's the author of many law review articles. His commentary has appeared in the New York Times, Wall Street Journal, Washington Post, and other national publications. He's testified before the House Judiciary Committee on the constitutionality of executive action on immigration. And maybe most importantly, the founder of Fantasy SCOTUS, which is the internet's premier Supreme Court fantasy league.
Don't play.
We have Professor Primus, who all of you likely should know. I'll just hit some of the high points of his esteemed career. Attended Harvard undergrad, Yale Law School, holds a Doctor of Philosophy from Oxford, where he studied as a Rhodes Scholar. After law school, he clerked on the Second Circuit for Judge Calabresi, and then went on to clerk for Justice Ginsburg at the U.S. Supreme Court. The format for today is going to be about 25-ish minutes for Professor Blackman, which will include some of the history of how we've gotten to this current iteration of the executive order, and then 20-ish or so, or however many minutes Professor Primus wants to take. And then we'll take a pause for just 2 minutes for people who have to leave for classes so that you can go without interrupting the speakers. After those 2 minutes, then we'll open it up to questions. So if you can think of any, please hold them until the question and answer period. And without further ado, I'll turn it over to Professor Josh Black.
Thank you so much. It's a pleasure to be back here in Michigan. Professor Primus is an old friend. I'm glad to always spar with him on one side or the other. I'm grateful to talk about the Supreme Court's case concerning the travel ban. But before I get to that case, there's another case I'd like to discuss that you may have studied in constitutional law, Texas versus Johnson. This case considers whether a person can be arrested for burning an American flag, long before people took the lead they burned the flag. Now, this decision broke down on a 5-4 line, but to the surprise of many, the deciding vote was cast by Justice Scalia in favor of the flag burner. Now, Scalia was no fan of flag burners. He once said, quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." But I am not king, Scalia said. Indeed, Scalia felt the answer was compelled by the Constitution, by the First Amendment, even though he disagreed with the result. Texas versus Johnson is a good gut check for lawyers. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. Travel bans, but several now. I'm a libertarian and generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is an awful policy. The executive orders will cause undue hardships to families, to refugees, and others simply seeking a better life. I am also doubtful this will do much to improve our national security. Yet, with my cards on the table, I am convinced that Congress gave the President the power to take these actions, and the Constitution does not bar him from exercising the powers in the manner in which he did. So I'll try to cover 5 different elements. First, I want to walk you through the history of the travel bans, going all the way back to statements made by then candidate Trump, as well as statements made by now President Trump. Second, I want to discuss the contents of the 3 orders, there are 3 now, which have all been halted by the courts. Third, I want to discuss whether Congress has afforded the President the power, the authority to take these actions from a separation of powers perspective. Fourth, I want to discuss whether these actions conflict with the First Amendment, that is, the Establishment Clause. And finally, if I ever get to it, I'll talk about what the Supreme Court will ultimately do when this case finally winds its way back up to the court, I think, this term. So we have to begin our discussion in December of 2015. Then candidate Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. That was a verbatim quote that Trump said. Over the next few months, Trump shifted his position from a Muslim ban and moved toward what he called extreme vetting of people seeking entry to the U.S. from certain territories. Or did he actually change his position? For example, on a 2016 interview in 60 Minutes, he told Leslie Stahl, call it whatever you want, but we'll call it territories, okay? Was that actual repudiation, or was it a wink and a nod to the alt-right? A week later, in Meet the Press, Trump seemed to repudiate the old policy. He said, I'm talking territory instead of Muslim. That's not a coherent sentence. Do you mean it? Is this fake news? I don't know. Fact checkers have aged years in the last 8 months trying to keep track of his various tweets and everything else. Alas, now the burden of reconciling these statements has fallen to the federal courts, who look to these sorts of press conferences and tweets to figure out the president's true intentions. Okay? Now we come to the inauguration. On January 27th, feels like forever ago, January 27th, President Trump signed the first executive order on immigration. I'll call this 1.0 to keep it easy. Version 1.0 said that for 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, Yemen, 7 countries, that certain aliens from those 7 nations were deemed detrimental, that's a key word, detrimental to American interests, would be denied entry. And the refugee admission program was suspended for 120 days. Syrian refugees in particular would be denied entry indefinitely. Now, almost immediately after 1.0 was signed, chaos began. Airport officials began to detain nationals as they came over. Did anyone run to Detroit Airport when this happened? None of you. Okay. Well, other schools they have. They're more caring, I suppose.
I think you missed hands that were raised.
Oh. Okay, well, proud. Very good. The chaos that was unleashed was this. People who left the country had proper paperwork, and when they landed, they didn't. In other words, while they were in the air, the new policy was implemented, which I think was a very bad idea that no one was given advance notice. The judges began to issue what are called habeas corpus writs, releasing from custody various people being detained. Many of these were green card holders who had basically a property interest to enter the United States with their paperwork. But that was only the beginning of the lawfare. Shortly thereafter, the Washington Attorney General sued and sought a nationwide, a global injunction barring the enforcement of this executive order. The judge's opinion was only a couple sentences long, didn't give much analysis. It was basically a TRO saying maintain the status quo. Generally, you can't appeal a TRO. The government did anyway. And they sought an appeal to the Ninth Circuit. The Ninth Circuit affirmed the opinion, ruling that this was a violation of the Due Process Clause. Now, this due process argument didn't really go too far. The future litigation focused on the Establishment Clause, so I will focus more on that later. President Trump sought rehearing en banc on the Ninth Circuit decision, denied over a couple of dissents. At that point, the president could have gone to the Supreme Court. He did not. Instead, they said, okay, we'll try again and issue a second executive order. 2.0 came in March 2017. The new order superseded the first one. It had a couple changes. Forget it. It sure was haunted against her, I suppose. You know, the ghost of James Madison's haunting us, I suppose. The second order removed Iraq from the list. It also made clear that green card holders were not subject to the ban. I think the second one was definitely a correct change. But it also shifted the justification. Rather than quantifying whether aliens from these countries engaged in terrorist attacks, which I think was always the wrong question, the new findings would establish that the U.S. lacks sufficient diplomatic relations with these 6 countries to trust their screening mechanisms. Okay? Surprise, surprise, the second order was challenged in court, and federal judges in Maryland and Hawaii issued global injunctions barring their enforcement. Those opinions were appealed to the 4th and 9th Circuits, respectively. They handled the cases a little bit differently. the Fourth Circuit sitting en banc as a whole, right? They didn't even go to the panel, they went straight to en banc. The Ninth Circuit sitting en banc said, well, this is a violation of the Establishment Clause. That is, the president's animus towards Muslims, as reflected in the statements before, during, and after the election, taint this action and make it unconstitutional. The Ninth Circuit ruled in a different fashion. They said that under the statutory regime, the president has not made specific enough findings to justify the denial of entry to these classes of aliens. I'll get to the statute a little bit later, I promise. These cases were then appealed to the Supreme Court. Eventually, the Supreme Court granted certiorari. But in the meantime, they did a couple of various things. There were these what are called unsigned orders, or called stay opinions, of whether the lower court opinion should go into effect. And we spent much of the summer arguing about whether grandma and grandpa are close enough relatives to fall within the scope of the Supreme Court's order. I'm not going to bother with that because that's all old news. Because on September 24th of 2017, the second order lapsed by its own terms. The 90 days had run. And we get version 3.0, right? So now we're up to the present. 3.0 was a proclamation, not an executive order. It makes basically no difference. This new order identified what they called a baseline for each nation to meet with respect to what's called identity management. That is a person who the papers say they are. After a thorough process where they reviewed hundreds of countries around the world, ultimately 8 nations remained deficient. So the good news is for Sudan. Sudan was on the list. They are not on the list anymore. Joining them, though, were North Korea, Venezuela, and Chad. Now let me talk about those 3 nations. North Korea, as you might imagine, doesn't send many people to the United States. The number of aliens from North Korea is I think it's less than 100 a year. It's a very small number, so it's basically irrelevant. The other addition is Venezuela. Now, it's not the entirety of Venezuela, it's certain diplomatic officials in Venezuela. So again, we're talking a fairly small number here. And then we have Chad. Now, many people might not know much about Chad. It's an African nation that is a majority Muslim nation. So it doesn't really get much. So you have Chad, Iran, Libya, North Korea, Syria, Venezuela, and then in Yemen, right? So you have these countries that are now on the list. The addition of Venezuela and North Korea, I think, doesn't really do much, and Chad doesn't really do much either. In fact, they're somewhat of an ally in the war on terror. Okay? Surprise, surprise, version 3.0 was challenged in court, and breaking news in the last 4 or 5 days, federal judges in Maryland and in Hawaii issued a new round of global injunctions, barring the enforcement of these provisions. The district judge in Hawaii ruled on the statutory question. The district judge in Maryland ruled on the constitutional question. So these cases are going up. Briefing to the Fourth Circuit is already done. It was filed, I think, last night. I suspect briefing to the Ninth Circuit will be done this week, give or take. And I expect the circuit courts to roll in at some point in the next couple of weeks or so, at which point we will get, again, you guessed it, a cert petition. And we'll be back to the Supreme Court, if I had to guess, Richard, maybe by December or January, does that sound reasonable?
Wouldn't surprise me.
Yeah, maybe by December, January, maybe February if they go on bonk again. But I think December or January, we'll get another cert petition, at which point I think the court will grant arguments, hear it in March or April, and then we'll get a decision by the end of June. Okay, that took me 15 minutes to explain the posture of the case. Now, at long, long last, I will get to the actual argument portion, because every time I give this talk, the beginning gets longer and the end gets shorter. So our starting point is a statute, which I alluded to before. 8 U.S.C. 1182F, enacted in the 1950s. And it provides, whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation, that's the proclamation bit, right? He may by proclamation, and for such periods as he shall deem necessary, suspend the entry of all aliens or any class of aliens, blah, 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 blah. So what that statute says is when the president deems it necessary, if he finds that certain aliens or classes of aliens would be detrimental, he can deny their entry. Now, this seems like a broad delegation of power, and it truly is. I would think the statute actually has vulnerability under the non-delegation doctrine, but for the fact that I think the president has his own Article 2 power here, which is why the statute, I think, is merely declaratory. I don't even think the statute is necessary. I think the case would come out almost the exact same way, even if it's never been enacted. But it's here. We have it. Presidents for the last 40, 50 years have used this statute on a number of occasions. President Carter, President Reagan, President Clinton. For example, President Reagan denied entry, told Cubans for a bit. President Clinton denied entry, told Haitians for a bit. Remember the boat crisis, right? When these proclamations have been issued, there's never been much of specifics. We determine these are a threat because of X, Y, and Z. There's simply been, we are denying entry to Cubans, period. We're talking one or two sentences here. There was never any allegation that this statute required specific findings of fact. That is, until the Ninth Circuit's recent ruling. The Ninth Circuit said you need to have very specific facts to justify such a broad denial. And the President's generalized proclamation, that is, not case by case, but a generalized sense, did not cut it. This has never been the standard. If the courts want to make it the standard, they can do so. But no president has ever been held to this before. The Ninth Circuit accepted as much. In fact, the judge in Hawaii, I appreciate his candor, he said, well, the fact that previous actions were not challenged does not make this lawful. Okay, I'll accept that. But I think under established precedent, the president has a statutory authority to deny entry. But there's a second component here that's worth discussing. In the 1965 Immigration Act, the big INA, the Congress enacted a provision that said when you're issuing visas, you can't discriminate on the basis of nationality. This was a really big deal because before that we had quotas. You know what the quota system, right? Where certain European nations got lots of visas and certain other African nations, for example, got very few visas. This was meant to destroy the quota. So the question is this: does this restraint on nationality-based visas impact the president's power to deny entry? I think the answer is complicated, but ultimately, if you read the statute, I think if you look at the second paragraph, it says the secretary can set various procedures for issuing visas. I think you have to read that to allow a carve-out for national security. If you don't, you run into some Article 2 problems. But I do think you can synthesize the statutes in such a way that this is not a violation of the statute. But you don't care about the statute, right? You care about the Constitution. That's why you came here today. So I'm going to spend the rest of my time talking about the Establishment Clause. Usually, when you think of the Establishment Clause, think of a case involving, prayer in school, right? Or maybe a Ten Commandments monument in a courthouse, right? Those are your traditional Establishment Clause cases. This case is different. The argument is this: by issuing this policy, the president has shown an animus or disfavor of Islam, right? By favoring Christianity, he has shown a disfavor of Islam. And there are some Supreme Court cases, Valenti and others, which say that you can't show disfavor of one religion over another, that itself amounts to an Establishment Clause violation. Now, if I was a lawyer and looking at this case, I'd say, wait a minute, isn't this a free exercise case, right? You're basically punishing people for their exercise of Islam, the faith. Okay, that argument doesn't work because people outside the U.S. don't have free exercise rights. You say, wait a minute, isn't this an Equal Protection Clause violation? Again, people outside the U.S. don't have Equal Protection Clause rights. What about due process, Josh? Well, when you're an alien outside the U.S., you don't really have a vested property interest to entry. You're here but for the grace of our country. The reason why the Establishment Clause argument has gained the traction it did is because it's structural. Michael Dorff, Professor Cornell, has stated this very well, that the structural aspect of the Establishment Clause limits the president's actions by itself. Like, per se, it's a violation. So I think this is probably a free exercise case, maybe with protection, but because of the nature of who's affected, they've had to pigeonhole this into Establishment Clause. Okay, now why is this important? Maybe three reasons. First, there is zero precedent on the book for the proposition that the Establishment Clause controls immigration policy. Now again, if the court wants to extend the Establishment Clause to immigration, they can do that, but it's never been done before. I have some evidence, right? We have a statute that's been in the books for decades, which gives priority for visas to, quote, evangelical Christians. We have a statute that says that. Now, a domestic statute giving preference to evangelical Christians wouldn't survive 5 minutes, but there's never been a doubt about this other statute. We have regulations in the books that say if you are a minister or a priest, you get priority for visas. And it specifically references what kind of priest, brother or sister, monks, nuns, whatever, right? It references members of the Catholic faith. Again, if this was domestic, it wouldn't stand for 5 minutes. So I think there's a pretty good argument that the Establishment Clause is simply inapplicable to these foreign policy decisions. I really do. I haven't seen any judge address this yet. I think the Supreme Court will have to. Because if you start saying that Our domestic immigration law is bound by our domestic establishment clause law. There are a lot of new claims that can be raised about asylum law, about entanglement, about how much can a judge probe into a person's religious beliefs when deciding asylum determination. These are hard questions that are raised here, but maybe I'm wrong. Okay, let's say I'm wrong. Let's say the Establishment Clause does apply to the president. Okay, then what are we basing our case on? The face of Proclamation 3.0 is neutral. There's no reference to religion at all. There was some stuff in 1.0 and 2.0 which I can talk about later, but the third one, the one we're actually considering now, has no reference to religion at all. So you have to say, aha, animus, right? This is Justice Kennedy's favorite word in the English language, animus, right? Actually after dignity, right? Dignity, then animus, right? So what is animus, right? What does this phrase mean? Well, hatred, disfavor, dislike. And how do we establish animus? Well, dummy, look at what Trump said, right? Look what he said. How could anyone deny it? I read it for you, right? A complete and total shutdown of Muslims. I read it to you 5 minutes ago. So I think we have to separate this evidence into two bodies. You have statements before the inauguration and statements after the inauguration. Why am I separating them? There is zero precedent ever to show that a candidate, his statement is going to be held against him as an office holder. There's no precedent for this. Perhaps I'm naive. Maybe I am. Maybe I'll be wrong. But I view the inauguration, don't you chuckling, right? I view the inauguration as something of a baptism that cleanses you, that you take this oath and you now have a government. You now have the president. You're the commander-in-chief, leader of the free world. That really should change a person. Maybe it does, maybe it doesn't. But I'm very nervous about establishing a rule that you can look to statements on the campaign trail to bind the candidate. Okay? But let's say I'm wrong about that, right? Let's say I'm wrong about that. What about the post-inauguration statements? The post-inauguration statements, and you can go through them, they're far more ambiguous. For better or worse, Trump dropped his call for a Muslim ban and he wanted a territory ban. He had statements, but it's not politically correct, this or that or the other thing. I actually think that you can look to a president's statements after the inauguration. I'm actually was rare. I said this last year also. I think you can look to the president's statements. But here, I think our standard review is rational basis review. I think that's all you get. Now, with a rational basis review, you don't get beyond the record. Now, why am I saying rational basis review? We have a case in the books from the 1970s called Kleindens versus Mandel, M-A-N-D-E-L. This case involved a Marxist professor from Belgium, and he sought to enter the United States. For what purpose? He wanted to enter the United States to lecture on, you guessed it, Marxism. He applied for a visa to lecture in the U.S., and surprise, surprise, the Nixon administration denied it. Now, what was the reason they gave for denying this visa? That, oh, well, you overstayed your other visa, you didn't check in with us, basically all these technical things. Does anyone think that's the reason why the visa was denied? No, right? They denied it because the guy was a Marxist. There's not much of a doubt there. Now, this was challenged in the Supreme Court in a decision called Kleindens versus Mandel. I don't think anyone had standing in this case. I think the case had been tossed in those grounds, but this was the 70s, different rules pertained. So they let it go ahead. Now what the court said is, we are not going to second guess these sorts of decisions. Our review is limited to facial legitimacies and bona fides, right? Justice Marshall, though, in dissent said, wait a minute, you guys, just peek behind the reason, right? Just look behind the reason and you'll see that this was denied because of a First Amendment violation. He lost. Marshall didn't even get Brennan. Brennan didn't even join that opinion. Okay. So in my mind, we had to see a rational basis review, and I think that was the law for decades. And not even Justice Kennedy's opinion in Kerry v. Dinn from a couple years ago changes that. Here we had a case where a woman applied for a visa for her husband. Her husband was in Afghanistan. A government agent said, aha, your husband worked for the Taliban or some such stuff. We're denying him entry. No more specifics than that. That was it. And they said, please, just look at the record, right? This is not the real reason. They denied it for some other reasons. And even Justice Kennedy said, no, as long as it's on its face, it's a legitimate reason. It's a good faith reason. That's it. I don't think in the foreign policy context, immigration sphere, courts can peek behind and look for good faith decisions. I don't think that's a precedent. Now, maybe I'm wrong. I've said this since March and February. If Justice Kennedy decides that we are going to now start applying something greater than rational basis review to denials of visas, if we're going to start applying the Establishment Clause to denials of visas, my word, immigration law will look very, very different. Because a lot of claims that could never have been brought before can now be brought. So this is my way of synthesizing the entire case. under fairly well-established, settled law, this third proclamation, I think, will survive. If the court decides that, no, those laws are not good, we're going to shift the precedent, well, then, I'm not a fortune teller, I'm a lawyer, right? I can't predict what's going to happen. But I think the reaction of these judges so far has been to push and extend the doctrine in ways that have not yet been blessed by the Supreme Court. Now, maybe the Supreme Court will do it, maybe they'll agree with it, maybe they won't. But under current law, I think these orders stand. I am right at 25 minutes, so I'm going to stop, sit down, and turn it over to my good friend, Professor Primus, and we will have a discussion. Thank you all so much.
Let me start by thanking the Federalist Society chapter for organizing the event, and by saying, as I sometimes do, how much it is a privilege, not just to teach the school with a Federalist Society chapter that engages in thoughtful conversation, but also to be invited to speak in front of the silhouette of a man who not only knew that the equipopulous composition of the U.S. Senate was a travesty and denial of all justice, but argued fervently in favor of vesting Congress with the authority to nullify all state law for any reason, and believed when the convention wouldn't do that, that the whole system was probably for naught. I want to make two big picture points, and then engage more directly at a lower level of abstraction with the points that Professor Blackman has made. And I want to say at the outset, Professor Blackman is a good lawyer, and I think that he has presented the most cogent arguments, both on the statutory ground and on the constitutional ground, for the entry bans that I've heard. He has done that from the very beginning, from 1.0 forward, and I want to recognize that. Here are the two big picture things that I want to mention at the beginning. One is about the motivations for the entry bans, and one is about the problem with evil. The big picture point about the motivations for the entry ban is this. The entry bans are motivated by bigotry. This is a fact, like Manila is the capital of the Philippines. Professor Blackman says, and I believe him when he says, that he thinks that the bans are awful as policy, for immigration reasons, for national security reasons. What Professor Blackman hasn't said is whether he thinks the bans are bigoted. He hasn't said that he thinks that they are bigoted. He hasn't said that he thinks they aren't bigoted. I know, in pretty much the way that I know that Manila is the capital of the Philippines, and I think you know, I'm not sure that Professor Blackman's proposition, he hasn't said it, I'm not going to put words in his mouth, and this goes for the Solicitor General of the United States too. I'm not sure that their proposition is that they don't know either, or that their proposition is it's not bigoted. Different here maybe for the Solicitor General and for Professor Blackman. The proposition that I hear instead is courts may not know. May not know, not factually, but permissively. Courts are not authorized to know and to act on that. I think not knowing requires, if not willful blindness, then at least strongly motivated reasoning. People, normal people, me, well, I don't know if I'm normal people, me, normal people, and me, whether that includes me or not, people, are given to motivated reasoning. This is the thing that happens often. Right? When we want something and the state of the world is at odds with it, we're often quite good at persuading ourselves not to see the thing that is there to be seen. I think that really not to know requires that. And I think the argument that more cogent analysts are making, on the other side from mine, is not that they don't know, but that courts may not be permitted to know and to act on that knowledge. Now, I think that it is the case that courts properly give the president the benefit of the doubt across a lot of spheres, including immigration and national security, and that's important. But the benefit of the doubt is different from willful blindness. The benefit of the doubt is one thing, and benefit in the absence of doubt is something else. Benefit in the absence of doubt is abdication. Big point. Big point two is about the problem of evil. Here, so you don't wonder, I am nursing an injury to my right leg. If at some point I sit down, that's why. The problem with evil. I believe in evil. I believe that it is a thing that exists. I believe that it is a thing of which people are capable. I believe, for example, that I am capable of it. And the reason that I believe that I'm capable of it is that I'm human. And I think that evil is a thing of which humans are capable. I should say at exactly this point, because the structure of this conversation is debate, that I am not here to tell you that I have looked into Professor Blackman's soul and found it evil.
That was a haunted Madison before that was a
Very good, right? Or perhaps he has cause to haunt us. What I am, I will say further. I've known Professor Blackman for some number of years, and though I do not know him closely, I will say that he has always presented in his direct interactions with me as a very friendly person. But I think that almost everyone looks back in history and identifies episodes as evil. We're willing to do that. And I don't see any reason to think that evil is a thing that existed in the past and has disappeared from the earth. I think that it's sometimes difficult to call evil by its name in your own time, except for people for whom it is all too easy. So I strive not to be the person for whom it is all too easy. I disagree with a lot of views in constitutional law. I don't often get up and identify particular positions or policies as evil. I can give many examples. But this is evil. The ban, it's evil. It's evil because it's bigoted. It's evil because it does really serious harm to people and to American policy, which the harm to which does further harm to people. It's evil. Now I want to say, the fact that a government policy is evil does not necessarily mean that it's unconstitutional. It doesn't. There are many evil things that the government can do without violating the Constitution. Many. And I agree fully with Professor Blackman that it is important to distinguish between things that are evil and things that are unconstitutional. Conversely, things that are good and things the government is permitted to do. But the fact that these categories are not coextensive does not mean that something that is evil might not also be unconstitutional. I think what it does mean is this. What should the lawyer do when faced with policy that is evil? When Justice Scalia faced policies that he felt were evil and were of questionable constitutionality, I think he worked hard to discover that they were unconstitutional, from his point of view. That's appropriate, stated in that way. That is to say, if you're faced with an evil and it's obviously unconstitutional, well, fine, what are we doing for it? And if you're faced with an evil and it's obviously constitutional, well, that's regrettable, right? And try to do something about it, in politics or otherwise. If faced with an evil about which you entertain doubt, or faced with an evil where you think, you know what, I could make some good creative arguments to show you why this might be constitutional, you have to ask, why do that? I mean, maybe you have a client. Maybe you're bound ethically to serve your client and that's the side you're on, and there are reasons why you can't resign the post. And so forth. But if you're just you thinking about this question, and there are really good arguments that the thing is unconstitutional, and then you hear an argument, oh, you know, maybe, if I look at it this way and I squint and so forth, maybe that's constitutional. If you rest there, you're not doing your job. Justice Scalia, in Texas versus Johnson, had a very firm, clear view about the First Amendment. I don't really believe him about locking up all the scruffy weirdos. I mean, I didn't know him personally well enough to know that with a high degree of confidence, but I doubt he really thought that. I think he really thought he was happy to live in a society that tolerated some dissent. I'm just speculating. Those are my big points. Now, I'm not going to contest Professor Blackman's statutory argument. There's a statutory component here, there's a constitutional component here, and I'm not sure that Professor Blackman is wrong about the statutory analysis. I'm not completely sure he's right, but I think he makes a pretty good argument on the statute. I think that is a reasonable argument that a cogent legal analyst could rest on. It might be right. I'm going to talk about the constitutional part. And I gotta say, I don't think this is hard. And I'm going to talk about the constitutional part under these three headings. First, the question of the unconstitutionality of the orders, because they are discriminatory, because they are motivated by unconstitutional animus, variously as matters of equal protection or free exercise or the Establishment Clause. Briefly, about the demonstration on the available record that these things display animus. And then something about the scope of review, right? What is it that courts can know and do in the immigration context? As I'm following Professor Blackman's template, more or less. Okay. Professor Blackman says, first there are questions about applicability, right? Do these apparatuses apply at all in immigration, or when we're talking about the rights of people located outside the United States? Professor Blackman says that equal protection doesn't apply to aliens outside the United States. I want to say two things about this. The first, one can separate questions of standing to raise from questions of the validity of action in the first place, right? Even if it were the case that no one would have standing to raise an equal protection claim based on something done to aliens outside the United States, it wouldn't follow that the president is authorized legally to do those things. You all know that, right? Some things are just unconstitutional. Unless you have a fully mechanistic, positivistic picture of constitutional law where nothing is unconstitutional until declared as such by the judiciary, which you could have. Right? Power is given subject to limitations, not subject to limitations and the institutional contingencies of litigation thereafter. Right? On this point, I am at least as libertarian as Professor Blackman. Now, it's true, Professor Blackman, I think, is right this far. I cannot cite a Supreme Court holding in which the court has struck down federal action on the basis of a violation of the rights of aliens outside the United States with no connection to the United States. I can't cite such a case. I can cite cases in which the Supreme Court has analyzed federal law as if those rights exist. I can cite a case in which Justice Scalia analyzed federal law as if such people had equal protection right. The case I'm thinking of is a case called Pangilinan. Oh, did I say Manila? Maybe this is why I used Manila. This is a case about Manila. It's about Filipinos. It's a case in which a bunch of Filipinos raised an equal protection claim saying that they had been treated impermissibly by a U.S. consular official in Manila, and they raised it as an equal protection claim. And the court, Justice Scalia writing, denied the equal protection claim on the merits. If it were clear that equal protection just doesn't apply, they don't even need to get to the merits. Now, they did not affirm the equal, they did not vindicate the claim. I cannot cite as precedent, see it applies. But I don't think there's any precedent that holds squarely that it doesn't apply, and this case comes to mind suggesting that at least the courts have thought that it did. If it's true that equal protection simply categorically does not apply in such a situation, then here's the proposition that we have to swallow. The proposition is that Congress could constitutionally forbid tourist visas to all black persons. Period. Done. No issue. I don't think that's constitutional. Call me crazy. I don't think it is, because we have equal protection. And I see no precedent pointing the other way. So I think it is at the very least a choice to ignore something like Pangilinan and say, doesn't apply. And I'm not sure why I would make that choice. Professor Blackman also says the Establishment Clause doesn't apply in immigration sorts of contexts. But here's what I heard as the shape of the argument here. Professor Blackman he did not cite cases in which the courts have rejected Establishment Clause claims on the grounds that this is about immigration with which the Establishment Clause has nothing to do. That's not the kind of precedent, right, that constitutes the argument. The precedent is there are some things the government has done which you might think raise Establishment Clause questions, and they are still on the books, which indicates the Establishment Clause doesn't apply here. The thing is, I heard 3 examples. They are all so easily distinguishable. I may or may not get these in the order that Professor Blackman suggested. One's a statute that's been on the book for several decades about priority for evangelical Christians in immigration. If I'm thinking of the same statute that Professor Blackman is, it's a late Cold War Reagan-era statute about immigration from the Soviet Union. It gives priority to Jews and evangelical Christians from the Soviet Union seeking to immigrate to the United States. That's that statute. What's that statute? It's a relief from persecution statute. That is to say, the statute uses categories within the Soviet Union, Jew and evangelical Christian, as proxies for people suffering religious persecution, because there was a large public awareness at the time of persecution against people in those religious categories on religious grounds in the Soviet Union at the time. Right? It's actually, in the 80s, it looks very, very much like the kind of proxy that was used in affirmative action statutes that used racial labels as proxies for disadvantage in affirmative action programs. At a time before Adirond and Croson, when constitutional law was much more tolerant of affirmative action than it is now, and much more tolerant of the use of demographic proxies for the actual thing. I don't think this is an Establishment Clause problem. I don't think it's about preferring certain religious groups. I think it's a statute that basically says these people are suffering religious persecution. We have general policies about immigration to shelter people who are suffering religious persecution. That's what this statute is. And it doesn't take long, I think, to realize that that's what's going on in that statute. I think another example was about the way that, I wasn't sure if I heard this. I heard parts of this, so I might be synthesizing incorrectly. About the status of religious persecution more generally in asylum. You mentioned something about asylum. It's true. Immigration judges and other authorities who process asylum for the US government think in terms of religious persecution in appropriate cases. But again, that's not an Establishment Clause problem. Okay? The Establishment Clause blocks the government for acting for religious reasons, right? Or to prefer some religions to others, which is done for religious reasons generally. Okay? It does not say the government may never notice anything about religion, including the fact of religious persecution, which is a ground for asylum on par with several other kinds of persecution. Yes, you can think about that one too. That's all it is. First Amendment doctrine on religion very much reaches for the apparatus in the 21st century of neutrality, right? That is to say, if you're considering religious persecution in the same way that you consider various other kinds of persecution and endangerment, it's not an Establishment Clause problem. It just isn't. The third example is the pastoral statute, right? Creates an immigration preference for religious ministers of one kind or another. And I'm of divided mind on this one. I think there are 2 possibilities. I think one possibility, and the one that I always used to like best was, yeah, that one is just straight up unconstitutional. It is. It's just unconstitutional, right? In my more charitable mode, and I think that under present doctrine, my more charitable mode is actually more likely to be correct than my first impulse, is the one that says, the path, but I don't know enough about immigration, about the details of immigration law to know which is right here. The question is, in the general scheme of immigration law, are there other exceptions? Not exceptions. Are there other preferences for people who are key employees in institutions in the United States, parallel to this one, with pastors for religious organizations, such that to exclude the pastor is actually to treat religion worse in violation of the First Amendment? And I don't know whether that's true or not. But either because that's true or because that one's just unconstitutional, I don't think it carries, the example carries a lot of water. So, all these distinctions, I think, all these examples, I think the distinctions come very quickly and easily. Why wouldn't I make them? Why would I just throw up my hands and say, I'm sorry, there's nothing I can do? The Establishment Clause. That doesn't seem like the best account of the law here. I think maybe what motivates it, and Professor Blackman speaks about this, is the fear of new claims, right? If we say that aliens abroad can raise complaints based on the Establishment Clause, the Equal Protection Clause, what are we opening the door to? And I understand that concern in general. I just am not worried about it as applied. I'm not worried about it as applied because this is not a case about like close questions about like raising subtle points of law. This is a case about open declarations of animus as publicly as possible. That is, like, if what we're afraid of is that animus at this level will be consistently redressed by the courts, I would say, and a good thing too. And I don't think we're going to get a lot of cases like that. I mean, the truth is, if we have presidents who speak like this president going forward, we might, right? Easily. It's never happened before because presidents didn't used to talk like this. Once we're in the world where the Establishment Clause and or the Equal Protection Clause applies, I think the case is super easy. Animus always violates equal protection. Right? If the reason that the government does something is we don't like them, that violates equal protection. Lots of cases. If the government does something because it wants to demonstrate favor of one religion or hostility to another, that violates the Establishment Clause. Now, I recognize that this argument that I'm making as applied is only as strong as the claim that the bans are, in fact, motivated by animus. So, let me say, just by way of clarifying, for these purposes, saying they're motivated by animus does not mean there is no purpose for which any official could ever have instituted a policy that looks like this one that would not have been animus-based. That's a different proposition. The proposition is this one was done for either entirely or inter alia. Inter alia will do. Right? Partial motivation is enough. At the very least, it shifts the burden in a serious way. This one would not have happened but for that animus. Where that animus is some uncertain combination, I do not know what the proportions are, of policymakers who don't like Muslims and policymakers who seek the support of voters whom they believe will support the policymakers for demonstrating that they don't like Muslims. Without those forces, these bans never exist. And I will spend basically no further time and descend into no greater level of detail supporting that view of the world. Any comparison between me and the great Charlie Black is insulting to the great Charlie Black. But those of you who have read an article that Professor Charles Black wrote half a century ago after the school desegregation decisions about why those decisions were right, the article basically goes, hey guys, segregation is about white supremacy. And if anybody argues about that, all I have for you is the sovereign prerogative of laughter. The thing is, I'm not laughing. Charlie Black could write that. It was several years after the decision. I'm not laughing about this. The Fourth Circuit wrote in its now vacated opinion that the executive order drips with religious intolerance, animus, and discrimination. I think they're right. I think it takes a lot of motivated reasoning to think otherwise. And I want to also just say one last thing about this. The proposition, I don't care that it could have been done for some other reason by someone else. Right? For this, I will cite that great lefty anarchist William Rehnquist, who wrote in Hunter versus Underwood, right, the case challenging a provision of the 1901 Alabama Constitution that had the effect, though not the facial purpose, of disfranchising a lot of black voters. I'm paraphrasing Rehnquist. Dudes. Alabama. 1901. Here's what they said about black people at the convention. I don't care what other purposes you say it serves. So what we're down to is, courts can't know. For institutional reasons, for doctrinal reasons, courts may not know these things and may not call animus when they see it. I think of course they can. Look, I agree, it is often hard to know what President Trump is thinking. But not always. Sometimes it's kind of clear. What are the arguments that say the courts must pretend not to know?
Do you want to break your people are packing and leaving?
If people need to leave, I'm happy to break for a minute and let people walk out and go for a minute so people don't feel that they need to disrupt.
We're not done.
Josh, thanks for suggesting it. So what are the arguments that say that courts must pretend not to know? So one's the argument that says we should not listen to things that Donald Trump said before he was president. This is either a proposition about causation and epistemology, right? It just actually isn't indicative of his reasons for acting afterwards. Or else it's a fear of letting such things in because candidates say all kinds of crazy stuff and we don't want courts to act on them. If it's the first, I just don't get it, right? If it's the first, that like things that I say on Tuesday are some evidence of why I do things on Friday. I think this is a common sense proposition, and if you want to take into account that in between I said I'll never do that, that's okay. Take account of that too, and remember also what I said, and then ask yourself what's the most reasonable story to tell about why this happened. I think that Professor Blackman's agreement with me on this point, I don't know, is why he uses the metaphor of the baptism, right, which is supposed to evoke a kind of otherworldly magic, right? It's not a normal, natural forces sort of explanation. It's a different kind of thing, right? The oath washes clean, or something like this. But why? I mean, it's not transferable. Here in the state of Michigan, it's illegal to pursue race-based affirmative action if you're a state university. Suppose we had a candidate for dean, and the candidate for dean said to the alumni, and said to the faculty, and said to the students, when I get in, I'm going to find ways to pursue race-based affirmative action. And then he becomes dean, and starting the next day, things change at the law school that look to the finder of fact like the pursuit of race-based affirmative action. I think the Supreme Court of Michigan will say, you know, he said, and I'll say, yeah, he did. He really did. If the fear is that if we let courts look at campaign statements, we are opening the door to all sorts of claims that we don't want, then I think this fear is a little overblown. I think it's overblown because judges aren't idiots. Judges know the candidates say lots of things. The fact that a candidate says something doesn't automatically invalidate something downstream, right? What we have in this case is pretty unusual, right? We have a candidate who openly made statements that we thought we had seen the last of from candidates for office in American history. If that's the set of statements that are going to get office holders in trouble in the future, then I say, yeah, and a good thing too. Last, the scope of review. I agree with Professor Blackman about what the relevant case law is here. It's Klein against it's Kerry versus Dan on the immigration front, right? What's the scope of review for judges reviewing executive decisions in immigration? There's this wrinkle, but I'm not going to make too much of the wrinkle. Those cases are about retail immigration decisions, and this is about a policy, and I have to think through whether those are on all fours or whether there's a distinction. But let's assume for the moment that they're the same. The key legal phrase, I think we're agreed, is the government's explanation. The court will not second guess where the decision is facially legitimate and bona fide. And the question is does facial modify only legitimate and bona fide is different? Or does facial modify both legitimate and bona fide? Right? If it's facially legitimate and facially bona fide, you're in. Or does it have to be facially legitimate and actually bona fide? Right? Because let's assume for the moment that Order 3.0 is facially legitimate, because it doesn't talk about Muslims on its face. And here I want to note, right, and I'm just like repeating something that Professor Blackman said. That's much more true of 3.0 than it was of 1.0. But I think Professor Blackman thinks that all of his arguments in favor of 3.0, or at least a sufficient number of them, also run against 1.0. Because Professor Blackman, as he said, is defending the constitutionality of the orders from 1.0 forward. Right? We're not resting on that distinction. It seems to me that facially can't modify bona fide. It modifies only legitimate. Right? There's a weak reason and a strong reason. Right? The weak reason is the obvious linguistic point. Facially legitimate and bona fide, if it just means one thing, it's redundant. We don't need bona fide. Facially legitimate is enough. I think that's a relatively weak argument because legal formulas have redundancies, right? That sometimes happens, right? But I think there's a stronger argument, right? Which is to say that that's all you need. It's like, why would you do that, right? The point of testing bona fides is to look behind facial legitimacy, right? Facially legitimate and facially bona fide just means, right, on the face of the order you gave a reason that would count. Maybe you gave a reason that would count, and as you handed the order to your subordinate, you said, by the way, I'm doing this for unconstitutional reasons, right? But it doesn't matter, it's facially legitimate, right? And facially bona fide. To say facially legitimate, there is no such thing as an order that has a facially legitimate purpose, but not a facially bona fide purpose. We would just have a doctrine that says, tell an obvious lie. Tell an obvious lie, and we're all good. And I think that deference is really important in these contexts. Judicial deference for the executive branch. But that's not deference. That's just pretending you don't know. Do we really think the courts should never question a national security explanation or an immigration explanation, no matter how much common sense tells us that it's a pretext for something evil? I don't think that. Now, last, outside the frame. I use the word evil. I think it is. I think the people who put forward something evil. I think the people who defend it and execute it are enabling something evil. I'm willing to say that. I don't think evil is disputed. I don't think that I'm immune from it. I am perfectly capable of engaging in or enabling evil. I hope people will call me on it when I do. I can think of instances where people might say such things. I am not predicting that the Supreme Court will take my view of the matter. I don't know what I would have predicted when Korematsu was going to be argued. I wasn't alive. I don't know. I can't think myself back. I don't know what I would have predicted. What I know is that Korematsu was wrong. And if the Supreme Court upholds 3.0, the court will be wrong. 4 justices who were in the majority in Korematsu also ruled with the court in Brown. I don't think they were particularly evil people, as Supreme Court justices go. But people who are not, as a general categorical matter, evil people are sometimes vulnerable to accepting plausible sounding legal arguments for deferring to the president in national security situations and denying that what they have done is racist or enabling of racism. That's what happened in Korematsu. And I think that when faced with a situation like that, what I ought to do is to say, this is unconstitutional. The law on it leads me easily to that conclusion. And that's all I need. And I apologize for going a little bit long.
Anyone wants to go, just go. I don't want to.
Yeah, we have the room till 2:30.
Oh, yeah.
Did you want to respond?
Yeah, if you need to go, just go. I don't like talking to people.
Go ahead.
Yeah, let's do it.
Sounds good.
So let's go.
The room dwindles. Well, I thank Professor Primus for his remarks. There's actually a lot that we agree on, and some things I think we will disagree on. One of the themes he advanced is this concept of motivated reasoning. And if you haven't read much about it, there's a good book called Thinking Fast and Slow by Danny Kahneman, Nobel Prize winner. And this notion of motivated reasoning provides that we generally reach the conclusion we want to reach first, and we implicitly reach for arguments that support that conclusion. And it's not to say that anyone's evil, is the word of the day perhaps, but that's a facet of human nature, that we usually reach the result we want first. I began this talk with the Texas vs. Johnson case for a reason. I really dislike the president's policies. I truly do. I don't like defending policies that I disagree with. In fact, I haven't filed an amicus brief in any of these cases for that reason. I'm one of the only law professors who hasn't. But I was struck very early on by the judiciary with engaging what I thought was motivated reasoning. If you looked at the decisions in the early travel ban cases, they were often. They were not exercises of judgment, as Hamilton would say, but exercises of pure will. Federalist 78. I'll give you a very easy example. The original Ninth Circuit decision was an appeal from a temporary restraining order. As appellate procedure goes, you can't appeal a TRO. You can only seek what's called mandamus. The government didn't seek mandamus. And there was one judge in the Ninth Circuit, I can't remember his name, who said, what difference does it make if it's a PI or a TRO? And that just hit me like, whoa. They saw it, as Professor Primus said, as evil. So you can drop whatever neutral principles of procedure you have and rule as such. And they basically affirmed what should have been basically a dismissal. And had they dismissed it, it would have gone back to the district court in Washington. He would have issued a PI a couple days later, and then gone back up the usual path. But those sorts of niceties haven't really mattered. You again had the original Ninth Circuit decision based on due process, even though there's no allegation ever that people outside the United States have due process rights. I'm like, whoa, what's going on here? So I was struck very early on by these cases. And these didn't come as a surprise to me. I actually researched the statutory questions, which I think we somewhat agree on, last year. Right? I wrote an article back in, after the Indiana primary called Trump's Constitution of One, where I listed all the various unconstitutional things I think Trump was about to do. Eminent domain, shutting down the internet, I listed them all. I didn't list this, because I had researched this, and I said, wow, I think a territory-based travel ban would be lawful. So why am I giving you all of this? Charges of motivated reasoning go both ways. It's a dual, the door swings both ways. I try not to base it on that. What I try to say is, look, we have, I think, a president who is uniquely dangerous. I believe that firmly. I think he is. I didn't vote for him. I don't think I'm voting for him in a couple of years either. So he makes it that far. If votes is saying Luis Mensch has it right, then maybe we'll make it that far. The marshal will take him out. But the point I'm making is, just because I think a president's dangerous doesn't mean we should give up precedent. And the fact that the Supreme Court on 3 occasions has pushed back on the Ninth Circuit with stay orders. Now, they haven't given Trump a victory, but they didn't reject him. Gives me some faith that maybe I'm on to something, right? That maybe this isn't the next Korematsu, that maybe this is an instance where the lower courts have simply panicked, and they've seen an evil, and they've abandoned precedents. So I'll end with where I began. If the Supreme Court wants to shift their doctrine and make clear that the Equal Protection Clause controls here, and make clear that the Establishment Clause controls here, and makes clear that statutes which Reagan, Carter, Bush, Obama have all issued now require the additional findings, okay, I'm wrong. I will gladly confess error. But if we're going to have a judicial revolution of these precedents, let it be from Anthony Kennedy, right? Not James Robart in Seattle. Let it be from our overlord who tells us who can get married, who lives, who dies, right? And not from these lower courts. And at each instance where the Supreme Court has intervened, they've told the Ninth Circuit, you didn't do it quite right. Now, here's my own personal prediction, however prediction. I don't think the court's going to rule on constitutional grounds. I think they just say the Establishment Clause isn't applicable here. And I think they will read Mandel, as Kennedy did, saying we're not going to look behind the curtain, right? We're not going to see why this Marxist was denied entry. I think it's a very specific ground where the government can give a victory and a defeat to the Trump administration. I haven't read this up yet, so you're getting breaking news. The statute at issue is 1152A1B. You can pull it up. 42 USC 11, whatever. Section 1152A1B. My brain's fried at this point. And that's a statute that says when the government's issuing visas, they can't discriminate on the basis of nationality, right? That only applies to immigrant visas, not non-immigrant visas. Did you notice in all the Supreme Court stay orders, they had this thing about bona fide, right? Who has a close relationship, right? I think they're just going to toss out people on immigrant visas. Non-immigrant visas. If you want a tourist visa, you'd be subject to the ban. But if you want an immigrant visa that you have a relation with a U.S. person or U.S. institution, you're within the auspices of this statute. I think that's where the court gives a split victory to the administration. I think I'm leaning towards that every day more and more. But the only wrinkle is subparagraph B. You have 1152A1A and A1B. Section B says that the government can establish procedures. That's the word they use. Procedures, notwithstanding A. So you can discriminate on the basis of nationality if you have these procedures. And what the government argued in their last brief, I hadn't seen it before, but I noticed it, is that the procedure at issue is the proclamation, right? The proclamation establishes the procedure by which they get out of the non-discrimination provision. Now, there are problems with that on both sides. On the one side, if we take that seriously, the president can nullify the INA and just say, we are going to deny entry across the board. But I think ultimately, what might win the day is the Article 2 power I mentioned at the outset. That to avoid reading the statute to infringe the president's Article 2 powers, we'll read procedures in a way to allow him to do what he's done. If the court takes that, the policy is upheld. If the court rejects it under the purpose argument, I think with respect to immigrant visas, the government loses. But that will still allow them to deny entry to people on a tourist visa or what's called a non-immigrant visa. I think as of today, and it changes every day, that's where my mind goes with this case. So this isn't a case from oral evidence. I'll look at the evidence, and I look at all the statutes, and I consider from 1.0 to 2.0 to 3.0 how the arguments have shifted. But I'm especially motivated it's a reason, I suppose, pun intended, to take an argument that people don't. Call me Jude, St. Jude, right? I like taking hard-fought, obscure cases, whether it's this or the Emoluments Clause. I'm drawn to things that people don't like. I don't know what about it. It's just been since I was a kid. I'm drawn to popular clauses. But I try as hard as I can every day to reassess my priors, always be cognizant of them, and that's why I'm here today. Thank you all so much. We have time for some questions. If you have to go. We're way past schedule, but I'll stay here as long as you need.
Nobody's here.
Yeah, so please ask me questions. Yes.
Yeah, I have like a two-part question on the Professor Primus. If you said this was mainly a result of this case should go one way because of the statements of candidate Trump, the animus that he portrayed against Muslims. My question would be, had a previous administration like the Obama administration done the exact same proclamation, would we reach the same result?
Of course.
And then the second part of this question is, would the animus that Trump displayed during the campaign towards Muslims, towards Hispanics, etc., would that ever impede him from using his Article 2 powers, such as if he, I don't know, uses commander-in-chief against a Muslim country or against maybe, I don't know, Mexico?
Well, let's think about the question precisely. If the question is, would it ever impede him? The answer is, well, yes, obviously, right? That's what constitutional limitations do, right? The constitutional rule says that the president cannot segregate the schools on a military base by race, right? Is a rule that blocks his exercise of Article 2 powers, right? That's what they do. It's easy. If you're asking, does it prevent President Trump from ever doing anything that adversely affects Muslims? The answer is, well, obviously not. Right? I don't see any categorical rule like that. Right? The question is, in the context of the particular policy or decision or action challenged, what does the court think the motivation was? Courts are required by doctrine to ask this question, right? In First Amendment context and equal protection context. The courts have, I'm not sure this is a good thing, but the courts have held consistently that a challenger cannot win an equal protection case, or in most circumstances, a First Amendment case, without showing what the purpose of the governmental decision maker was. Right? If that's the doctrine, then the court is in the business of deciding what the purpose was. And that purpose is decided retail, right? So, the question would be in any future case, why is the president doing this? And the answer might be animus or it might be not. It would depend on the facts of that case. This case looks to me easy because I don't have trouble drawing the causal story.
So let me give you another example. One of the other, the other obscure cases I like following, which is the DACA litigation. Now, as a matter of policy, I support the Dream Act. I think it's a good piece of legislation. I also think it's illegal. I'm always in this weird spot where the stuff I like I think is unlawful. It's just bizarre. Like Groundhog Day, where people wake up like, wow, I wish Congress did that, but they didn't. So there was a recent action by President Trump to rescind DACA, and it was challenged in court by the attorneys generals of like 15 or so states. And the New York Attorney General said one of the reasons why Trump can't rescind this deferred action policy is because there's animus towards Muslims. Animus towards Mexicans. It's almost like an ad-lib, right? Animus towards Mexicans. And what did he say? He kicked Jorge Ramos out of a news conference. Enough. He talked about building a wall. He took an MS-13. He said because of Trump's animus towards Hispanics and Mexicans, he's disabled from moving this policy, right? This is where the animus argument leads. Now, I think for some people it's like, yes, Trump is disabled from doing anything that can be traced to his campaign statements. Trump has pissed off virtually every demographic in the country except for white men. And you just go down the list. He's expressed animus for virtually everyone. You can draw, the causation I think is a key word. I think there's too much attenuation with DACA, but you can draw this link anytime you want. And if that's the doctrine, then I think Trump's presidency will be, I think it'll be short anyway, but I think it'll be shortened even more so than what he can accomplish.
And on this, let me say, I disagree on the last point. I think Trump's presidency runs to the end of the 4-year term, but I'm out of my depth making that prediction, right? I agree that the argument that Professor Blackman articulates about DACA is attenuated. Like, if I were the decision maker hearing that argument, I'd say, I don't think so here, right? Against backgrounds of deference, and you're like, I don't think that I would say yes to that. But I think what's important to recognize is when Professor Blackman says that's where these arguments go in the mouth of a litigating party, right? I mean, parties to litigation say all kinds of aggressive things, right? I don't think it would be responsible of a court, right, to accept that.
We'll see. As I say, see you in court. Next question. Yes, right here.
I was wondering, for Professor Primus, given Trump's campaign statements, what immigration restrictions can he do constitutionally? Like, what would be an example of something he could do?
Basically anything that any previous administration had done, like since the 60s.
So I'm pretty sure Obama limited certain immigration from Syria and Iraq, I believe, at one time. I'm trying to be mistaken. So he could do.
Well, no. Here's the thing. Like, focus on the analysis. The question isn't what can you do. The question is why are you doing it. He could do exactly the same thing, right, at two different times for two different reasons and so forth. And the question is, why did he do it?
Yeah, but because he said those statements, you could always say he did a certain immigration thing for a...
I could always say that. The question is, would I, as a responsible decision maker, believe it to be true that that was the reason? Right? Can I think myself into the view where I say, yes, this policy was likely adopted, right? Or it was highly plausibly adopted, right? For a reason that is not rooted in anti-Muslim prejudice. Right? This is not a complicated judgment to make. Right? That is to say, we make judgments like this about the actions of the people who we see around us all the time. Right? Why did he do that? Right? That's all the analysis that I think is needed here.
So this is for you. Give Professor Primus a break. So you were talking about the, if we change the standard to rational basis, then it sort of overturns all the precedents in immigration law. So what I was wondering is, should there or could there be a different standard between individual visas and a policy or a mass denial?
Thank you. I'm really glad you asked the question we did. So I think Richard and I may have been on the same page here. I think Kleinitz versus Mandel is only about a case-by-case basis. I made this point several months ago. I don't think Kleinitz is applicable at all to this case, at all. I think if you're applying for individualized visa, these are facial challenges to the executive order. No one has actually been denied a visa under this precisely because it never went into effect, which means we don't even get to facial legitimate bona fide. I think we're rational basis pure, which means we don't look at the other stuff. So I think they need Kleinitz versus Mandel because it gets to the, well, bona fide is this or that. I can go either way of that, but I think under the standard here, we're in rational basis land. Thank you for the question. Yes, patiently waiting in the back.
Professor Blackman, I'm curious what you make of the distinctions that Professor Primus drew around the Reestablishment Clause examples. Do you see those same distinctions, or?
Well, so there was an article written in the 1980s by Professor Tercios, and this was long before Trump was president, and the article thesis was this: the Establishment Clause in immigration law is like a black hole, right? Courts have just simply never addressed it. And she identified a couple of these pieces, some other things which I've cobbled together, as evidence as a matter of practice. I think Noel Canning, there's an established practice that it just doesn't apply. I don't have any judicial precedent. There have been lots of immigrants who've tried to challenge things in court, and I've not found a single case where they've been successful in raising the Establishment Clause. That tells me, as a matter of course, they're not part of our polity, right? Think of, what was it, Verdugo Aquiles, right? The Fourth Amendment case, right? Who does the Fourth Amendment apply to? Or the case last year where someone shot a bullet across the U.S.-Mexico border, right? Is that person going to be bound by the Fourth Amendment? These are very tough questions, and I do think that maybe this is where you disagree, our Constitution applies to our people. Maybe I sound like nationalist, but I do believe that. Now, the court does address that, and maybe I'm wrong. Maybe the court says that we have extraterritorial application of the Constitution. But I think it applies to U.S. citizens, people in the U.S., so if you're here, right, you're in the United States, you get pulled over, you get Miranda warnings. I'm okay with that. If you're in the United States and you want to picket for free speech, you have that. Even this case in D.C. with this woman, Jane Doe, seeking an abortion, right? The argument was when you're in the United States and you're not here legally, you don't have 14th Amendment rights. I think that's wrong. If you're in the United States, you're a human, you're a person. The 14th Amendment applies to you. Outside the United States, unless you are a U.S. citizen or a lawful permanent resident, I don't think you get constitutional rights. And I mean, that's my position long before Trump came into office, but I think that's been more or less the court's position as well.
And I think it's a little more complicated, right? I think as a matter of doctrine, some things go one way, some things go another. I mean, I don't think that we have a flat doctrine that constitutional limits never apply outside the United States. We have them again, if nothing else. I think the Constitution, you can say the Constitution applies to our people. I think it also applies to our government, right, in its acting. And I think that harm is done domestically and not just internationally from policies like these. So I think there's an argument here to be made. The thing that, but I think what maybe most divides the two of us on this point is this. I am telling you that I cannot cite a Supreme Court decision which has found an Establishment Clause violation on the basis of a federal action, right, whose force is only against aliens overseas, right? And Professor Blackman can't cite one, right, that says nothing like that ever will apply, right? He can cite examples in which it hasn't applied, right, where it might have been. I don't think that his argument about whether it applies there or not is Rule 11 sanctionable, right? Like, I can't cite a case that goes exactly the other way, right? But I also can't cite, this is caricature what I'm about to say, I also can't cite a case that says that the Establishment Clause applies upside down and in the shower, right? Professor Blackman will say reasonably, this is not about upside down in the shower. The distinction between citizens and aliens, or between home and abroad, is a more material difference in common law than the distinction between upside down and in the shower and the rights. And that's true, right? But it does seem to me that it's not right to say precedent precludes, precedent requires. We would be violating precedent in the powerful sense of judicial precedent to say, no, but this applies. We haven't said otherwise, right? And look at what we're talking about. Why would you feel so strong? Like, my hands are tied. I don't like this, and I must accept the evil result, is a thing that I understand saying in the face of square doctrine blocking my path. Right? But in the absence of the square doctrine blocking my path, what competent lawyers do is say, that path is open, and now I make an argument about it.
It's the back.
So one thought I had is, I'm looking at the blank on the case, I guess it's relevant to either of you, but the Guantanamo Bay case from the Bush administration.
Who made the answer, what he mentioned a minute ago?
Yes, I'm sorry. Where you did have due process rights extended to non-citizens in an area that wasn't technically...
Yeah, and I think Boumediene, if I remember, Richard, remind me, it was the territorial sovereignty of the United States. That was part of it. It was within our sovereignty. I think that's actually an important fact.
It's squishy.
Yeah.
Okay.
It's squishy. I agree with Richard.
So I guess my thought is how would you view the administration's ban? Let's say it's upheld. If someone who's a non-citizen goes to, say, like an American embassy or something like that, who's has a genuine claim to, in my view, like asylum or something like that, would they have, maybe like a real argument to make with respect to saying, no, this can't apply to me in this situation?
Well, asylum is a matter of statutory law, right? Congress has created a fairly rigorous framework of who can get rights. Asylum is not a matter of constitutional law at all, right? It's a matter of statutory provision. So that's not changed. And in fact, the travel ban still permits asylum claims from people from these nations.
Yeah. Tell me your name.
Holman,
I think the case you want, right, to pose the hypo, because I agree with Professor Blackman about the status of asylum here. I think the case you want to pose your hypo isn't an asylum seeker. I think you're interested in a person who has made his way into sovereign U.S. territory, like an embassy or like in the canals or somewhere, right? And then seeks to avail himself or herself of the normal immigration process and is blocked by the force of this executive order. I think that's the case that sets up the question that you are interested in.
In the U.S. or at the border? What's your hypo?
I think his hypo is they are inside the door of the embassy.
Yeah, that's not important.
Or maybe you would take in Guantanamo. That might be the easiest, right?
Guantanamo, Kennedy's opinion said that it wasn't within the territorial sovereignty. Which I don't know if I agree with, but that was the opinion. So if you're in a U.S. embassy, there's a general presumption that doesn't get you in. Even if you get to the border, right, within certain number of miles of the border, you can be turned around without any process at all, and there's statutes that affect. it's a gray zone, it's squishy, right? It's where does the boundary fall for constitutional rights? Yeah, let's take one more question. I'm getting hungry. Yeah, to that.
Professor Blackman, you indicated that bringing the Establishment Clause into immigration law would create this kind of scary, slippery slope of immigration officers no longer being able to inquire about religious practices and things like that. And I'm wondering if you can run that down for me a bit more. I don't understand. That sounds great to me. I don't understand why we would.
Well, I didn't say it was scary, but I said it would be a change, right? It would affect a serious change in the way immigration law operates. Let me give it to you like this. Let me explain the question like this. Under our immigration law, we have asylum, right? And one of the aspects of asylum is whether you have a credible fear of persecution. It could be religious, it could be political. There are several different grounds. And the sorts of inquiries that immigration judges make, where they may by a regular Article 3 court in another context, people say, oh my God, lemon test, right? This is excessive entanglement with religion. Now, I like the lemon test, I think it's wrong, but assuming we have lemon, it would put constraints on the ability of immigration judges to assess the validity of an asylum claim. So actually it could backfire and either make it harder to grant it, or alternatively, they could say, okay, you don't need to plead with particularity, we'll give you asylum. So maybe it cuts one or the other. I'm not saying one's better or worse, I'm saying it would affect change, I think, if now these sorts of hearings were subject to an Establishment Clause challenge. Imagine, right, you're an alien seeking asylum, and the judge asks you certain questions, say, Your Honor, I can't ask that because it's an Establishment Clause violation, right? And then, is that, you go to Article 3 court? Generally, these decisions are appealable through a very strict route. So, good, bad, I'll let you decide, but I think it would be different, it would be a change.
I mean, asylum seems like a specific genre of immigration claims where, I guess what the Primus indicated, fleeing religious persecution is specifically carved out as inquirable. That seems totally different.
Right, so let's say you were a Buddhist in the Soviet Union, right? You were a Buddhist. They existed, I'm sure they're somewhere. And you see the statute, it says, Jews, Christians get preference, but Buddhists don't. That's disfavoring my religion. Boom, animus, right? This was a Lautenberg amendment. It was exactly right. This was passed by a Jewish senator, right, to help Soviet Jews. That's why this thing existed. The evangelical Christians was a fairly small component. If I'm a Buddhist seeking, I'll use the other statute, the pastor statute, right? The regulation gives example of who a pastor is, and it basically gives example of people dedicated to religion for life, which is more or less Catholics. What if you're an Episcopalian part-time minister? Are you covered or not? You have to make a case. What if you're, I don't know, a member of the Baha'i faith, right, or the Sikh faith, or maybe another religion that has less, I don't use the word strenuous, but less strict requirements, who's a member of the cloth? You have disfavor of your faith right there. So, maybe Professor Primus is right. Maybe these statutes are just unconstitutional, just say screw it. But I put a lot of weight in executive branch practice. I put a lot of weight in congressional practice. These have been the books for decades. No one's challenged it. Maybe Donald Trump is the impetus, right? Maybe Donald Trump will make immigration law great again because he screwed so many things up, and will allow courts to reconsider it and inject some sanity into the process. Maybe that's right. But I will continue on this long crusade to argue in following precedent until Justice Kennedy, our dear overlord, tells us otherwise. Thank you all so much. Oh, that was my little Richard.
I know you want to have lunch. I know you want to have lunch, but may I ask one question?
You always may. You always may. What a build up.
As a factual matter,
yeah.
not as a legal matter, as a factual matter, do you believe that animus against Muslims played no part in the adoption of these executive orders?
It played a part. I wouldn't say no part. I think it played a part. Okay? Thank you all so much.